I'm Community Legal Education Association's Executive Director, Mary Trosco. It's my pleasure to welcome you to tonight's presentation on family law. And first, I'd like to acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and dedicate ourselves to move forward in the spirit of reconciliation. It's now my distinct pleasure to introduce our presenter, Len Fishman. Len was called to the bar in 1975 after graduating from the University of Manitoba. Len has focused his practice on family law. He and Terry Beley have been practicing together since 1992 under the name Fishman Beley Family Law Associates. Len's son, Noah Fishman, joined the firm in 2012. Len maintains the firm's website at www.fbfamilylaw.mb.ca. Len has argued cases in all the courts of Manitoba and has taken two important cases to the Supreme Court of Canada. Len lectured and mentored law students in the Faculty of Law's clinical family law course for over 10 years, was co-course head of the family law section of the Law Society's Bar Admissions Program for over 10 years, and chair of the family law section for 2 years. He has contributed to numerous Law Society continuing education programs and lectures on family law for our Community Legal Intermediate Training course, which these webinars have sort of morphed into. He's frequently appointed as an arbitrator by lawyers or clients, or as the Law Society's appointed chair on fee arbitrations and family law. Over the years, Len has been on various Manitoba Bar Association and court committees, currently as an originating member of the Standard Clauses for Court Orders and Family Proceedings Committee, which has just released version number 6. So I know Len is going to start right away, and what I was just going to mention is he's going to take questions as we go along. So please put them into the Q&A section so it's easier for Len to, and me to figure out where they are. So I'll let Len take it away. Thank you very much.
Hello, everyone. It's kind of strange. I'm sitting here looking at my computer and I can't see any of you, but I hope you can see me. I've prepared a PowerPoint and I'm going to run through it. I'm going to go as quickly as I can. I often go well over my time, so I'm going to try not to do that. And maybe your questions will focus me on the things that you're interested in or that you have questions about. You'll note on the first slide the website that I have and that I maintain. Most of what I'm going to say today will be found somewhere in there. It's got a pretty good search and index, so you can use that to hop onto wherever you need to go in the system. There's lots of links to rules, statutes, articles, things like that. Okay, so some of the topics, just let me move this out of my screen. Okay, some of the topics are marriage, common law, children, support for children, support for spouses, partners, property sharing, the family home, protection and prevention remedies, enforcement of orders, remedies, and recent changes in family law. It's hard for me to know what you're interested in, so I'm going to just skip along as quickly as I can. This is your usual joke about lawyers, of course, and how we're such terrible people who make a living off other people's misery. Marriage is something that we know as a function of what people do in our society and have done in our society for a long time, but it's really not quite as important as it used to be. Now, more and more people are living together, getting into common law relationships, things like that, and we'll talk more about that as we go along. Common law relationships are where two people don't have to be the same sex, they don't have to be even unmarried, live together, and when they live together and meet certain criteria, then the law will apply to them in the same way it will to the married people. The first thing they can do is pay $100 to Vital Statistics to register a common law relationship, and that will automatically put them under the law as it's available to married people. And then at the end of their relationship, they can dissolve that by paying another $100. Very few people do either of those things. Most people live together and do what they want to do, and really, it seems, don't give a lot of thought to what they're creating in terms of their rights and obligations simply by living together. If they haven't registered their relationship, having lived together for 3 years in what's called a conjugal relationship, and I'll talk about that a little bit more as we get along, they're entitled to all of the remedies that are available to married people with respect to support, child custody, child support, spousal or partner support, and division of their property. If they've lived together for 1 year in a conjugal relationship and there's a child of that relationship, then they have all of the same rights and obligations except for the property claims, and those still require the 3-year relationship. So what does conjugal mean? Typically, people understand the word conjugal to mean that they're having sex, but it's not a requirement any more than it's a requirement in marriage, I guess, after it's been consummated. So the fact that people have sex, that they live together, may not be enough to meet the criteria of being in a conjugal relationship. They have to sometimes prove it. And why is this important? It becomes important when we start talking about property, when we start talking about the dates that people separated and so on. We need to be able to know, when did their relationship start as a conjugal relationship of cohabitation. And then again, we apply the same kinds of criteria when we're trying to determine when the relationship's over. So some of the tests for a conjugal relationship are listed here. We can get back to them and I can explain them if anyone has questions about them. But essentially, it's how you act towards each other, how you act in society, how people outside of your relationship perceive you, what you say about it, how people see you, and so on. But again, what people do and what people say isn't always the reality. So sometimes we end up in a court. The court will have to make a determination of the facts. Did the parties really intend what they're saying now? And the same thing goes to the fact when people are separated. Sometimes people will separate, and I'll get to that a little further down the this talk about people living under the same roof but being separated. So when are they separated? They're separated when they've communicated to each other effectively that they're separated, not always necessarily for perhaps economic reasons or other reasons, not being able to move into a separate accommodation. You don't need to do anything wrong. You don't need to prove fault. You don't need to prove anything like that to have a separation. So those kinds of requirements have gone by the wayside. There's no formality required. I would suggest make a note, tell a friend, write yourself an email, something like that, if there's some question about whether or not you're going to be separated. And obviously, if that communication is to the other party, well, that's all the better. So as I started to talk about living together under the same roof, or being separated under the same roof, pardon me, may be important to prove the date for the purposes of a divorce, may be important for the purposes of proving values of property on specific dates. And of course, having that date, knowing the date you started to live together and knowing the date the parties have separated will be a prerequisite that the court will want to see as you move into something called triage, which is a new, well, not so new since 2019, form of judicial assisted dispute resolution, and a prerequisite to getting on to the next steps if the parties are going to move along the process to a trial. A divorce is different than a separation. Well, separation and divorce are different in the sense that firstly, you don't need a divorce unless you're married, but if you are married, you need a divorce if you want to get married again. We have what's called no-fault divorce, or usually no-fault divorce. The one ground of divorce being that there's been a marriage breakdown. Marriage breakdown can be proven by a year of separation. That's the most typical. By physical or mental cruelty, usually not something that people are going to go to the trouble of proving, or adultery, again, something they're not going to go to the trouble of proving unless they're in a big hurry to get divorced and there are no issues or something like that. Because if there's litigation involved, it's going to take at least a year to get that a separation and divorce resolved. The thing about a divorce and the thing about a separation is not so much the change in status. Are you living together? Are you still married? Are you separated? But what the corollary relief is, which is the all the things that we do when we go to court and try to settle a family law case. That what are we going to do with the kids? What are we going to do about support? How are we going to deal with who lives in the house? Who's going to continue to live there? Is the house going to be sold? Those sorts of things. Is someone going to pay support to the other? Those are the things that we really care about most of the time, not the fact of separation or divorce. Those are emotional issues for some people, but they don't make a whole lot of difference in terms of the facts. So you don't have to do anything. Doing nothing's an option. And a lot of people, of course, these days, are happy to go on Google and see what they can find out about the law and put together their own agreements. There's lots of sample agreements on the internet, all kinds of things that are available to help you resolve the issues. But because I'm a lawyer and I see it a lot, I'm going to try to promote people to go to lawyers and talk to lawyers, at least get proper advice before they do make a deal. Deals are possible. They don't have to be done through lawyers. They don't have to contain legalese, as long as the ground rules are there, that there's been adequate and complete disclosure so that no one is making a deal without knowing what they're getting, what they're giving up, that sort of a thing. And that they've had some advice and that they can certify to the court that they weren't coerced, that they weren't put under duress, that they understand what they're doing. They're dealing on a level playing field. So one size does not fit all, as I've written here. You should talk to a counselor, talk to lawyers, get some advice, figure out what you're doing. Agreements are respected by the court if they're properly done. And basically, if you want to do some research on that, at the bottom of this slide, you'll see the Miglin case, which is the Supreme Court of Canada case. I didn't give you a site for it, but if you just type it into any search engine, you'll find it. That's the case that basically set the standard for what an agreement must have in order for a court to accept it and follow it. The format is basically that there's been, as I said, full disclosure. There's been independent legal advice. That there's a level playing field, that it isn't the subject of one party lording it over the other, either financially or physically or mentally or whatever, that there's no duress or coercion. You've got to meet the criteria and the objectives of the Divorce Act. Corollary relief, that's what we're talking about here in terms of what the court can deal with and what people want the court to deal with, namely with respect to the custody and access for children, the support of children, support of partners, equalizing of property, and other things that go along with the separating of people's lives. Anything can be obtained under the provincial law, which is the Family Maintenance Act, which deals with separation, or under the Divorce Act, which is the federal statute, which dissolves the marriage. But in the process of doing that, we deal with all these issues of corollary relief. In terms of support for partners, basically, both the federal and provincial laws make provision for it. The starting point is a partner entitled to support? And that will be a question of what have been the roles during the marriage? Has one done things to the advantage of the other? Has one made sacrifices? Those sorts of things will be the key questions that are being asked when you come to the issue of entitlement. Once you've established entitlement, then the question becomes how much is the support? How long is it going to go for? Is it subject to conditions? What ongoing disclosure needs to be made? Now, the thing that's important to remember about spousal support or partner support, as opposed to child support, is the question of taxation. When we get to talk about child support, you'll hear that child support is not taxable. So the party who's paying child support will pay out of tax-paid dollars. If it's spousal support and there's a proper agreement that meets the criteria of the Income Tax Act, then that spousal support is deductible from the income of the payor and included in the income of the one who's receiving it, the payee, as income. So John pays $100 support. I'm not to be too sexist here by saying John or Mary pays $100 of support, they get to say to the income tax people, oh, deduct that $100 from my gross income. My gross income was whatever it was. It's now less $100. So I'm saving some money on income tax on that $100. Figure usually a third. So $33 is being saved on that cost of $100. So the net cost is $67. And on the other side, the person receiving the support, Mary or John, as the case may be, will declare that as income. So they then have to go to the income tax people at the end of the year and say, I received $100 of spousal or partner support. Tax me on that. Now, the original theory of that was the thinking that the party who was paying the support had a higher tax bracket than the party receiving the support, so that the government made up a bit of the difference between it. That may or may not continue to be true. As we started talking about the entitlement to support, we talked about benefits and detriments of the relationship. So benefits might be that one party has stayed home to look after children. Other benefits might be that one party has contributed to the assets that end up in the name of the other party. That may get sorted out when we get to the property division, but may not. There are sometimes detriments. Sometimes parties will move from one place to another. Say, typically we find that in relationships where one party is a member of the armed forces, for example, and may get moved around the country or the world, and the other party, in order to keep that relationship together, may give up seniority in their job, may give up maybe the qualifications of their job over time. So that's an initial thought. Have there been benefits or detriments? Has one party given something up? Has the other party gained something? Usually over time, there's something there. We talk about support in a couple of different ways. We talk about it as compensatory, namely to satisfy the compensation for the roles that have been played, the sacrifices that have been made in that relationship. So the court will most typically look at support in the compensatory side, but there's also non-compensatory support where one party, for example, may have become ill during the relationship and is no longer capable of dealing with things, making an income in the way that the other one is. The thing about support is that it's a judge's discretion. Who a judge will look at the relationship and at the end of the relationship have to make the determination that there's been something in the condition, means, needs, and other circumstances of each of the parties that makes support the right and reasonable thing to do. And then, of course, there's the question of, as I said before, the amount and the duration and the terms of that. And we'll talk about that a bit when we get to the spousal support guidelines. Support can be varied, and we'll talk about that a bit if it comes up as we move along. The spousal support advisory guidelines are, taking a look at the word advisory, it's important to note are a product of studies done by the government and reports made to the government with respect to the outcomes of divorce. Now, the spousal support guidelines don't determine if someone is entitled to support. What they do is apply some pretty complicated formulas to the incomes of the parties, the length of their marriage, and whether they're children, and who has care and control or the parenting responsibilities in relation to those children. Typically, it's not something that people are able to figure out without the use of software, and any lawyer that practices family law is going to have that software, usually Divorce Mate or Childview, which is the one I use. I can't believe I can't remember the name. So what the spousal support advisory guidelines do is they put forward a range. They say, okay, if you've been married for X number of years, this party's income is X amount and the other party's is Y. Here's the amounts that the court should consider as reasonable within a range. They give low, medium, and high ranges, or depending on the software, as many as 10 different iterations. The theory is typically that over time, the longer the marriage, the more likely it is that the parties' financial relationship will merge, that it'll become one unit, and that at the end of the marriage, when things have broken down, the outcome should mirror that. The SSAGs, or the SAGs as we call them, are used pretty commonly by the courts. They've been in place now for, well, I don't know how long, probably over 10 years. And although they started off very tentatively being relied on by the courts, they're now pretty much a part of every decision the courts make. Now, the courts aren't bound by them, as I've said that, but they typically follow them, and typically will explain, if they're not following them, why they're not following them. They typically are seen to work for incomes under $350,000, but they are sometimes used for those amounts over $350,000. Similarly to the way that child support, which we'll talk about, is handled. The theory is that support will generally last for 1/2 to 1 year for each year of the marriage. So if you've got a 20-year marriage, then you're looking at a range of between 10 and 20 years for support to last. And then there are formulas that over 20 years of marriage or following this, what's called the rule of 65, support would be indefinite. That doesn't mean forever, but it means without an end being put into the court order. So people do come back and they do attempt to vary orders that are indefinite, and they should not be seen as forever. They're typically seen as something that can be changed, but unless someone comes to court for that variation, won't be changed. I talked about taxation of support. I'll bump along. This one thing I guess I should say, there's support is typically either periodic, this much each month for the next number of months, or it could also be a lump sum. If it's a lump sum, it is not subject to taxation. Only the periodic support is subject to taxation. The big topic, probably the biggest topic that we have in family law, is usually about the children. That's where people are emotionally invested, and we're talking about human beings. We're talking about our children, or the party's children, which are not so easily reduced to numbers and facts. So both the Family Maintenance Act and the Divorce Act, which deal with custody and parenting of children, look to the test what is in the best interests of the child. Everything has to come back to that, and each of the statutes, and you can find them on our website. The Divorce Act and Family Maintenance Act define best interests of the child, and I'm not going to go through that right now. But a couple of things you should understand in terms of the way things are talked about is that the Divorce Act talks about parenting, whereas the Family Maintenance Act talks about care and control. So when you see those words in various court orders and documents, you may have to substitute one for the other to fully understand what's being talked about. The recent changes to the Divorce Act in the last couple of years have basically said, as I've got highlighted here, a child should have as much time with each spouse as is consistent with the best interests of the child. Now, that doesn't necessarily mean that it's going to be 50-50 each and every time. That may be subject to an issue of, is it really in the child's best interest? And that may require a look at the history, the past parenting, the current needs of the child, and a lot of other things, as you'll see from those statutes. But it does herald really the move towards shared care and control, or shared parenting, which compared to when I started doing this almost 50 years ago is a big change. 50 years ago, 45 years ago, mothers typically got sole custody. Fathers, if they were interested, maybe saw their kids every second weekend, maybe one evening during the week. The times have changed and the law has changed with it. It's not the case that every time there's going to be shared or equal parenting, but more and more that's happening. The real issue becomes what is in the best interests of the child. Can each of the parents adequately meet the child's needs? Are they each able to do that? Are they each willing to do it? Do they actually do it? And a big theme in the Divorce Act, as amended most recently, is to ensure that children are protected from violence and abuse. There are major issues now with respect to mobility, that it's not easy for people to just simply get up and go with children without notice, without abiding by court orders. I'll give you some quick look at the vocabulary. We started to talk about it: parenting versus care and control. As we understood it up till the change in the Divorce Act, we had joint custody, and that's still the norm. But joint custody doesn't necessarily mean equal time. Joint custody is really a discussion of the legal issues. Who has the right to give consent for a child? Who makes the decisions for the child? And that may be about medical things, health issues, schooling, religion, those sorts of things. Those are typically joint custody issues. More cases than not, I would say, give joint custody to the parents, so that the issue then breaks down to how much time do they have with the children and who makes the decisions. Care and control, parenting time, those are the two phrases. And really what they're talking about is, where does the child live on Monday? Where does the child live on Tuesday? Where does the child spend the summers? Those sorts of things. There might be primary care and control, which is the old language and still the language under the Family Maintenance Act. Now, if it's under the Divorce Act, it would be primary parenting time. So those kinds of bits of language can be a bit confusing, but the objective is to try to get away from what was seen as pejorative or dominating language about care and control or custody, trying to move towards the understanding that children have two parents, and that the parents have to learn to do the best they can to share their children for the children's best interest. In the old days, we talked about sole custody and access, where one parent had the primary care, they had the right to make the decisions, they had control, and the other parent had access, visiting rights, that sort of thing. Now, when we talk about shared custody, shared parenting, shared care and control, we're usually talking about it in terms of either 50-50 or some other variation, but the importance of it, well, I shouldn't say importance, the function of it, the practical application of it, boils down to the issue of child support. So where a child is in the care of one parent less than 40% of the time, or more than 60% of the time, they are not in a shared custody situation. The parent who has less than 40% of the time will pay support to the parent who has 60% or more of the time, and that's the definition of shared custody in the child support guidelines. Another form that we see sometimes is what's called split custody, where one child lives with one parent, another child lives with the other parent, or maybe it's 2 with one, 3 with another, whatever, some combination of that. And that again plays out in the child support paradigms that we end up working with. We now have, in addition to the parents having care and control, we have the issue of contact, where third parties and grandparents typically may apply to the court under the Divorce Act, as well as the Child and Family Services Act for contact. There are different tests under each of the statutes, and there isn't a lot of case law on that, but that's now available. The important thing with respect to children really, more often than not, boils down to decision making. Who gets to decide where the children go to school, which activities they'll be involved in, what religion, will they be baptized, will they be circumcised? All those sorts of things are the decisions that parents get to make, and more often than not, the court is unwilling to give one parent the power. So typically parents are required to consult with each other before making decisions, and may not often be able to make a decision without the court intervening if they don't agree. Parenting plans are now a requirement. The parties are expected to sit down and write out and put it in paper, file it in court, what they want or what they expect to do with their care of the children. I've given you a couple of links here for parenting plans. Some people get very formal with them, go on for pages and pages. Others do a 1 or 2 paragraph thing, but they're forced to go through the exercise. And I don't know if I said this before, but I'm going to make the PowerPoint available to Mary to distribute to anyone that wants it. And I'll try to get there's a couple of slides that I'm going to share with you that are not part of this, and I'll send those along as well. Assessments are something you've probably heard of that are sometimes used by the court in order to get an objective third-party view of what's in the best interest of the children. Assessments can be done by the court. Court has the Family Conciliation Services or Family Resolution Services, as it's now known, which will do those reports at no cost, but only if the court orders them. The court will sometimes order limited kinds of assessments, ones that will look at a single issue, perhaps, called a focused assessment, a health issue, a schooling issue, that sort of a thing, or maybe a mobility issue. Sometimes where the child is old enough, there will be a consultation with the child in an attempt to get what's known as the child's point of view, the voice of the child, as they call it. So those happen. Otherwise, the parties can sometimes agree, or the court will order that they have a private assessment, one that they're going to pay for, which are done by social workers and psychologists and people like that. But if only one party wants it and the court doesn't order it, it's not going to happen. The parties can agree on the cost, or sometimes they'll say, leave it to the court to assess the cost at the end of the day. They're useful, but people have to recognize that they often take a lot of time, and the cost can be quite high. Typically, I would say that private assessments tend to take 3 to 6 to 8 or 9 months and can cost $8, $10, $15,000. So it's a lot of money to spend, and there's a lot of time that will be put into delaying the litigation and the final result. Child support is really a big topic, and the courts have, or the law has been set up in such a way that hopefully people will be able to resolve the issues without the necessity of going to court, without the need for lawyers and those sorts of things. But it's the substrata there that we fight about. We fight about what's the party's income, which is the basis for setting the support, or should income be imputed to one of the parties because they're not doing what they can to earn the kind of income that they should or would be able to, in order to found what the support should be. The theory is that parents each have a duty to support their children, no matter what their level of care of that child is and what their relationship is with the child. And it's seen, although children don't tend to bring these cases forward, to be the right of the child. The child has an entitlement to be supported by his or her parents, and the parents don't really have the right to take that right away from the child, to give up the right to support for their own purposes. We also talk about children of the marriage, which may be someone that in the past we would call a stepchild. So someone partners with someone who has a child, assumes a parenting relationship with that child, may find that upon separation that they have an obligation to support that child. And also with respect to their own children, that they will have to pay support for them over the age of 18. And that typically happens when a child is seen as being dependent, and that is typically a child who's going to university or who might have some disability or health issue that makes it difficult for them to get on their own. Child support, as I said before, is tax-free, and that's a big piece of the cost of it, and why it becomes so complicated when we're figuring out under the spousal support advisory guidelines because the spousal support piece of it is tax deductible or tax payable, whereas the child support piece is not. We do have, as I started to say, child support guidelines, and those are intended to make it easy for people to figure out how much support to pay. So going back to the language of custody that I talked about before, if a child is in the primary care of one parent, the primary parenting by one parent, that is over 60% of the time, that parent is going to receive support from the other parent. If the child's in the shared care of the parties, that is in the range of between 40 and 60% of the time with each of the parents, then there's going to be another form of support payable, and that is one party typically paying the other what their income calls for, and the other paying the other what their income calls for, so that there would typically be a difference. But that's not always the case in shared care, although typically it is, which is really the formula for the split custody or split parenting situation, which I talked about before, where one parent has one child, the other parent has another child. They do the offset. And this is all done on the basis of each of their incomes and the tables. The tables are essentially mandatory, and they're set by the federal government. And I'm going to try to figure out how to load those up for you right now. I think I've lost that screen sharing. Not. I had it all set up before, but I can't remember how to do that. I apologize for that. Can I do this? Do you see those, or is that table being shared? Will someone tell me?
No, it's not. You're still on your PowerPoint.
Okay. Well, I'm not going to try anymore. I'm going to give up. But I will include it with the stuff that I'm going to send the links to. The way the child support guidelines work is that there are tables, and there are simple tables and more complex tables, and you'll follow the links. I think I give them to you at the end of this, or you can find them on my website, and you'll find calculators. But essentially, they set up a situation where based on the amount that based on a person's income, you'll look up on the table, you'll look up under their income, you'll look up the number of children, you go down the column, you go across the line, and you come up with the amount. And up to $150,000, you can count on that being the answer, that's going to be the number. If the income is less than $150,000, what it says on that table is going to be what a court's going to order 99.99% of the time. The fact that the person who is receiving the support may or may not need it is irrelevant. So you may find a situation where a millionaire parent is getting support from someone that's not making $1 million a year, maybe making 50 or 100 grand a year, but who doesn't have care of the children. That person will still pay support to the millionaire, and just using millionaire as being someone who presumably doesn't need the money. The theory is that the children will get the benefit of that money because the parent who has care, control, or majority parenting time will pass those benefits on to the child. So when we're talking about support, the first question we ask is, where are the children living? The second question we ask is, what are the incomes of the parties? And we need to know the incomes of both parties for child support, because there's something called Section 7 or special expenses. But starting with just basic table support, which is what we call it, we need to figure out what the payor's income is. And that may be simply looking at their income tax return, what's on line 150, but it may be a whole lot more complicated. If they own a business, If they are shareholders in a private corporation or something like that, there may be other considerations that we're going to have to look at to figure out what their income is. If they earn less than $12,000 a year, which is called the threshold amount, no support is payable. But every $100 a year over $12,000, they're going to pay something. When we talk about this, I think, and as you'll see, the tables, they go up to $150,000. And after $150,000, there's a percentage that can be applied to the excess amount. Typically, the court will simply follow that amount of income and order that percentage extra amount. That follows a case, the Supreme Court of Canada, that basically said what I've reiterated, or what I alluded to before, namely that it's assumed that the parent who has primary care of the children, primary parenting, is going to confer those benefits on the child, although often enough you'll have the argument that the millionaire, gazillionaire payor will be saying, well, the child support is really subsidizing the other parent's income, and they may or may not have been qualified for spousal support, but that the fact that they've had a children then gives them this entree to having more money than they would otherwise. That argument, often made, is usually not followed. The court will typically order much of the amount over $150,000 for child support, unless it gets really out of hand. So the theory is the child support guidelines are based on current income. What's that person's current income? Typically, we don't know what their income is in June, July, or August, but by the time we get to December, we're often having a better idea. But typically, we're looking at what they did last year, and that's typically seen as being current. And it would be noted in the court order that it's based on the 2021 and 2022 income. Where the income varies from year to year, some people get a bonus, they get overtime, or they simply do better at their jobs or in their businesses. The court has the power to average their income over 3 years. That doesn't happen a whole lot, but it does happen. And on the other side of it, the court will impute income to parties where they're not being fully employed, where they are not doing their best to make the income that they can, or particularly some people might downplay their ability to make income as a way of punishing the other party, as a way of lowering what they're allowed to pay, what they're required to pay for support. We have the typical case of the policeman in I think it was the Donahue case, who gave up his well-paying job with the Winnipeg police force to become a screenwriter. Well, whether or not he was ultimately going to succeed as a screenwriter and make the big bucks, the court said, no, you're going to pay support based on the income that you gave up, because what you did wasn't realistic, and it was perhaps calculated to deprive your children of the benefits of what you could earn. So that's a case that we have in the Manitoba Court of Appeal. If you run a private corporation, the court will want to assume that you're going to take out as much money from that corporation as you can. So they will sometimes add back the pre-tax income of the corporation where it hasn't been distributed. If you're self-employed, sometimes you get to write off certain expenses with Revenue Canada's approval. Maybe your car expenses, some travel expenses, your meals with your customers and so on. Those may be legitimate write-offs from employment income. Those may be added back by the court, even though they're legitimate write-offs. They may be added back by the court to impute income to you for the purposes of determining how much child support you have to pay. Other things like capital cost allowance, say you own a bunch of buildings, you're able to write them off every year for the purposes of your income. That by claiming capital cost allowance, that capital cost that you've deducted or that your client has deducted will be added back to their income. If you live in another country, for example, you live in the States, you live in some other country that has a different taxation system than Canada, that may be taken into account. They may add back income on the basis of grossing it up as if it were earned in Canada. Other countries, of course, have different ways of looking at things and doing things than we do. We included in our tax system, for example, is the fact that we've got universal health care, whereas perhaps in the States, you don't have that. Maybe you're paying insurance and so on, but as a result, you have a considerably lower tax rate. So those are considerations that the court may take into account, trying to figure out what your income might be. If you've got income on a reserve, that's not taxable. Again, that may be grossed up for the purposes of child support for a child off the reserve, or maybe even on the reserve. There's some adjustments that are made to that. We deduct union dues, for example, and there's some other arcane deductions that don't come into play very, very often. So I talked about before, excuse me, I'm going to take a sip, how the form of care or custody determines the amount of support. And as I said before, if you're in the situation where one parent has more than 60% of the time, then the other parent simply pays support on the tables. If they have split custody, they pay the offset amount. Parent A pays based on their amount for the number of children, on their income for the number of children in the other party's care. Parent B pays based on his or her income for the number of children in the other party's primary care. So that's an offset amount. The parties typically, in those sorts of situations, will also have to consider if there's the deduction that sometimes a single parent can make for one of their children. That's called the alternative eligible deduction. Not everyone can do it because they may have repartnered, for example, and if they've repartnered, then they can't use the child for that purpose. In a shared custody situation, which we're using that phrase to, or shared parenting, using that phrase to mean that the children are in the care of their parents between 40 and 60% of the time, we use the split custody formula typically, but the law allows for the court to take into account what are called the increased costs of the shared custody arrangement. Now, that's available, but again, it's something that it typically doesn't pay to pursue. It's simply easier to do the offset amount rather than trying to figure out what the increased costs of shared custody are. And that's just the way the law has developed. There's a very complicated case in the Supreme Court of Canada called Contino that talks about calculating those increased costs. And the reality is that from a practical point of view, almost no one ever tries to prove that. So there are some exceptions to the guidelines, and I talked about them a bit. One is where the children are over the age of 18 and dependent, going to school, etc. The court can also consider, does the child have income? Is the child getting scholarships, bursaries, that sort of thing, while they're going to university, if that's what they're doing. But typically, over the age of 18, we stick with the tables. It's rare that there's a departure, but now the Family Maintenance Act of Manitoba basically calls for those things to be reviewed by the time the kid's 24. I talked about the income over 150. I talked about in place of the parent. Undue hardship. If you can prove undue hardship, the court will adjust the amount of support, and it has the power to do that. But the definition of undue hardship is so complicated and so difficult to prove that, again, while a lot of people will make that claim, more often than not, it goes nowhere. It becomes a waste of their time, and if they're paying lawyers, a waste of their legal dollar. The court will look at the household sizes of each of the parties' homes, so that will then start to include partners, other children, shared care, all that sort of thing. And all of this information gets plugged into a formula, which, as I've said, more often than not, does not show what is needed to get a hardship claim approved. And once in a while, when a hardship claim is approved because of maybe excessive debt or some other responsibilities, the court will very often put limitations on it and ask for the parties to return within certain periods of time to see if those hardships carry forward. Another big ticket item in child support are what we call Section 7 or special and extraordinary expenses. Those are the things that people pay for that are seen as not being included in the basic table amount. So that might be in Manitoba, it's the kind of thing that often comes up as a hockey expense. Sometimes kids costing their parents thousands of dollars to play hockey every year. And that may be seen, depending on the party's income, the amount of the table support, as an extraordinary expense, something that should be shared over and above the table amount. There are tests as to what is a special or extraordinary expense, basically looking at things like necessity. Now, necessity might be that the child needs expensive medical appliances, orthodontia, that sort of thing. That's typically seen as a necessary, well, not typically, but often seen as a necessary expense to the child's health and best interest that may be outside of the ability of the parent that's paying for them to cover it on the table amount. Is it reasonable? Is it reasonable in relation to the family's economic circumstances? How did the family spend money before they separated? Is it in the child's best interests? Daycare is typically seen, sorry, I'll go back to that. Daycare is typically seen as a necessity that allows a parent to go to school or a parent to work. And so that would be typically a Section 7 expense. And like some other, or unlike some others, those expenses are often deductible for purposes of income tax. So it depends on who pays them. Sometimes each of the parent will pay their share directly so that they can get the tax benefit, or maybe they'll look at it so that one parent does pay it and they may get a better tax benefit, and they may work out how they share that amount. But it is certainly, usually without doubt, a Section 7 expense that has to be covered. Some of the expenses that people are claiming, like hockey, swimming, lessons, those kinds of things, aren't always accepted as special or extraordinary. Sometimes they're seen as ordinary. So we have to figure out, do they meet the criteria? Things like tuition for private school. You may need to get the agreement of the other side that the kid will go to private school. You may take it to court. There may be some special need of the child that private school is going to pay for. Secondary school tuition, going to university, college, that sort of thing, may be a Section 7 expense. And again, going back to what I talked to about before about kids over the age of 18, is the kid going to school full time? Is the kid doing their best? Are they applying for scholarships and bursaries and those sorts of things? Those may be considerations. So as we get to the definition of the word extraordinary, we start with the very simple, well, it's not ordinary. So what does that mean? Can this parent cover that expense? Is it reasonable? What's the amount being paid on the tables? How many programs is the kid in? Do they meet some special needs of the child, some special talents of the child? What's the overall cost of all the programs? And what else the court can take into account as relevant. Section 7 expenses, as these are known, are shared on a net basis. So when I talked about the daycare expenses, for example, might be deductible for income tax, that's something that gets taken into account. What is the net expense to the parent? Then the question is, how do they share that expense? Typically, the statute calls for the expense to be shared proportionately to the party's income. So I've given you an example here where one party's earning $50,000, you take off the threshold amount. The other party's earning $30,000, you take off the threshold amount. Then you do some dividing and you come up with the one paying, in this case, is paying 67%, and the one that's receiving the money, who has the primary parenting, it's costing them 33% of the net cost. Typically, parents will share those expenses on a 50-50 basis, particularly if they're sharing the care on a 50-50 basis. This particular slide looks like it's out of order. Yep, how did I get to it so quickly? Apologize. see this. You've got many more slides, and your ability to listen to me is probably getting a little bit fuzzy. I'm going to try to run through these things. As we talked about before, the support of children is an obligation of the parents mutually. So as a result, the thinking is that parents should be disclosing their incomes. They should be adjusting the amount of support payable, and that's easy to do. There's tables, there's calculators, all that sort of thing, as their incomes change, because the payor in particular knows what their income is. The one that's receiving the support may not, unless there's a court order that the other one's following to disclose their income, may not have a clue what the other party's making, and may not want to rock the boat by having to ask and that sort of thing. So the duty is upon the payor, and if they don't pay, particularly if there's a court order that says they have to give that disclosure, or that the case to be reviewed and maybe they haven't complied with that, then the court will go after them in terms of arrears, because they have that duty to disclose, and they know the information, and the one who is receiving may or may not be in a position or have the mindset or the gumption to go after the other party. There are lots of things that go on between people that make it difficult for them to do those kinds of things, even though they may be in their very best interests. The amount of child support is, of course, variable. It's what I talked about before in terms of the parents, the payors knowing their income, is all in support of the concept of retroactive support. The court will typically go 3 years back as a general rule, and if there's blameworthy conduct, which I alluded to before, which is where they haven't followed a court order, they haven't supplied disclosure on request, the court will go back more than 3 years if there's this kind of blameworthy conduct. I'm not going to talk about child welfare. That's a whole topic unto itself. It's governed by the Child and Family Services Act, and essentially very complicated and very heartrending in many cases, because it does get to the heart of the best interests of children who particularly we want to protect from abuse and neglect, but it's really beyond the scope of what I can cover today. And again, guardianship and adoption are also separate topics where third parties become involved in the lives of children to the point where they may become their guardian, look after them from a personal care point of view, or maybe just from an economic income point of view. Sometimes a child may be the beneficiary of an estate of a parent who died or something like that, or a lawsuit that maybe involved them. So they may need an adult to be the guardian of that income. Then there's the whole concept of adoption. Again, a large topic of its own, and I'm not going to go into it right now. I do want to talk a bit about property, because that's something I have often neglected in this kind of lecture that I've been giving. And I did receive an email the other day about someone who said that they wanted a particular question answered. I'll try to touch on that. The concept of property is governed on a statutory level by the Family Property Act in Manitoba, but there are other ways of dealing with property. But most of our cases are situations where we've got married people who are separated, or we've got a common law couple who meet the criteria that I talked about at the beginning. They will share their property as to value, not as to things, although they can certainly divide things up and put values on them, that was acquired during the length of the relationship. So whether they're married or not, we go to the date that they started living together. Lots of people will live together for a while, then get married, then later separate. We go back to that first date, the date they started living together, whether they were married or just remained in a common law relationship. Assets are shared and debts are shared on a fair market value, not the replacement value, not what it costs to buy the new fridge or a new toaster or a new couch or a new car. It's what you can get for it on today's market, your Craigslist, your whatever list you're looking at, Facebook, whatever, however you're going to deal with these things at auction, whatever. Sometimes we'll get appraisers in to value those things, but we certainly get appraisers in to value larger properties, buildings, houses, businesses, those sorts of things they also get included in the whole equalization of value that was acquired. And the question that was asked in that email was about the marital home. Well, it depends. If the marital home is in the name of one of the parties, then it falls under the Family Property Act, and it's shared, as all assets are and debts, on the date of separation. If the house is in joint names, the names of both parties, usually with the right of survivorship, the value of that property isn't shared until either we have a trial or that property gets sold and we find out what they get for it. So going back to that person's question, sometimes the party who owns the house in their own name on the date of separation will gain. If it's an upscale market for houses, as we've had for the last number of years, that may be changing, where houses aren't going to go up in value, presumably forever, although they seem to have done that for a long time. So that person may end up losing because they are seen or deemed to know what they want to do with their assets as of the date of separation. In the same way, they might have a stock portfolio, say worth 100 grand on the date of separation. Maybe 2 years later, by the time they get to resolve everything, maybe it's gone up, maybe it's gone down. Maybe that 100 is now worth 120. Well, good luck to them. Maybe it's worth 80. Too bad, so sad. They account for it at the 100. So the date of cohabitation, namely the beginning of the relationship, and the date of separation is a key issue. And I talked about that at the beginning, how we determine what those dates are. So that's a first thing, a first step that we need to do is figure out what is that date of cohabitation. If there's premarital assets, what is the date of separation if there's some dispute about that. The parties are entitled to claim for more than half. Typically, everyone claims it. Typically, it goes nowhere, and the end result of the accounting is 50-50. Sometimes we have what's called a negative accounting, where one person's set of assets minus their debts is a negative, that they own $100,000 in assets and $150,000 in debts, and they want the other side to share that $50,000 in debt. The court has a discretion whether or not to allow that. Some of the exceptions that we have to property are gifts and inheritances. So a party gets an inheritance from a relative during the relationship if they keep that money separate. And that's a mistake that a lot of people make, is they don't keep it separate because they think that they're going to last forever. If they keep it separate, they get to have it exempted from the accounting. It's not included. So that $100,000 you got from your aunt or your cousin or whatever it was, if you keep it separate in a separate account or in a separate commercial investment, that won't be shared. If you put it into the joint account, you convert it into a family home, you pay off the mortgage, those sorts of things, you lose that exemption. Assets that you owned prior to the relationship are excluded, although if they go up in value, that increase in value during the relationship will be included. If they go down in value, the decrease in the value of that asset will be included only to the extent that it offsets other increases in other assets. So that's a bit of a trap for the unwary there. The thing that is odd in Manitoba, and that sort of answers that question that person asked, is with respect to the joint assets that they own. So if they own a house jointly, they have a joint bank account, they own a joint investment account, those assets are in theory not included in the Family Property Act accounting, and they are shared as and when they are disposed of. So if the parties have a house that's in joint names on the date of separation, as they indicated, 2 years goes by before they sell the house or they deal with it on the accounting or whatever, that house goes down in value, that house goes up in value, whatever that outcome is, they share it equally, unless there are other issues that may be used as offsets. Couple other exceptions, they don't come up too often. I'm not going to talk about them too much. One factor is this one at the bottom of the slide. Dissipation is where one party has excessively lost the value of assets, gambled it away, put it up their nose or put it in their arms, that sort of thing. hundreds of thousands of dollars, perhaps the court may add that back into the accounting, even though it's been gone. But otherwise, what happens during the relationship, the court doesn't really care. The fact that someone paid for the car, or someone didn't, or someone added something to something, or whatever, that's history. What we care about is where things stood on the date of separation. So as I started to talk about the joint property, the house typically is not covered under the Family Property Act, but may be dealt with under the Law of Property Act, where one party may ask the court to have it sold in the meantime. And it also may, of course, be subject to occupation issues that one party will go to court and ask the court to give them the right to continue to live in the home while the other issues are being sorted out. And the court may also give one party the right not only to live there, but to stop the other party, excuse me, to may postpone the sale of the house, which a joint owner typically has as a right to have a house sold. When we're talking about the value of things, we're always talking about their fair market value, the auction value, the appraised value, the market value, the Kijiji value, those kinds of things, not what it would cost to buy a new one. So that fridge or that brand new TV that you spent $2,000 on isn't worth $2,000 6 months later or 2 years later. It's worth what you can get for it on the market, not what you would have to pay to replace it. It's a used assets. There's some assets that are difficult to value, so the court will do the best it can. Things like pensions, for example, are difficult to value. But, we get actuaries involved, that sort of thing, and we come up with values. An important asset for many people is their pension or their RRSP, which the pensions are difficult to value, and RRSPs are also difficult to value, but in each case, they may have what are called costs of disposition and income tax consequences attached to them. When you pull out your pension, typically it comes to you as a form of income, not as a lump sum that it may be valued at. Similarly with RSPs, when you pull them out of the RSP, you pay income tax on them. So the court will take into account the income tax value for RSPs and pensions when valuing them. So if you've got an RSP worth $100,000, typically the court will say, okay, we're going to discount that by 1/3, 30% to 33%, something like that, to account for the average tax value. Now, that may not always be fair, because when you're pulling out that RSP, you may be at a very high bracket, or maybe that you've reached the age where you must take it out, and you may have other income, you may not have other income. So whether that 1/3 or 33% or 30% is appropriate for you is often an inquiry that the court is not interested in. They'll just simply say, never mind, we're just going to impute that amount and take it off. Now, the thing about RSP, however, is that you can do a tax-free rollover on marriage breakdown. So it may be that one party's got $100,000 worth of RSP. If they transfer $50,000 of RSP to their spouse or their former partner, that former partner then will have $50,000 in RSP. The payor, or the one who's transferring, will have $50,000 RSP, so that will take it out of the accounting. Other than that, that $100,000 would be seen as worth, say, $70,000, and the other party would then get $35,000. So if they agree to that tax-free rollover, that may or may not work out for them. It may help them because they've got a lower income or higher income, as the case may be, and they're prepared to take the benefit and pay the tax cost at their own discretion when the time comes. Pensions, particularly Manitoba pensions, are typically shared by agreement, but if the parties want to, they can agree to opt out. And the rules with respect to that have changed in the last couple of years to the point where it's a whole lot easier, and the law is a whole lot less paternalistic in that regard, allowing people the discretion to get out of sharing pensions equally, so that we can then quickly value that pension and add it into the mix when we're totaling up assets and debts. Sometimes we'll have resort to the concepts of trust and unjust enrichment, where the Family Property Act doesn't fit in appropriately, where there's been what's called an unjust enrichment. An unjust enrichment is defined by one party being deprived of something, the other party being enriched by that person's deprivation, and that there's no legal reason for that to happen. So it's a complex subject. It's sometimes the catch-all at the end of the day where there is no other remedy, and it's just a little too complex for me to go into it right now. The family home, which I started to talk about a bit as a function of property and value, also has other attributes that may fall into the category of needing the court's attention. I talked about sole occupancy, the right to continue living in the house after the parties have separated, or postponing the right of the other party to sell. Those are set out in the Family Maintenance Act. The value, as I started to say before, depends on title. Is it joint title? And we value it when we dispose of it. If it's in the name of one party, we value it on the date of separation. Partition and sale, as I indicated, is a right that each of the parties has, and typically the court will order it, unless there's a good reason not to. It may be that it's necessary to keep that value intact as part of the ultimate accounting. The court may say, well, you know, that $50,000 of equity may disappear, even though it may be something that one party, by the time we get to trial, will have to pay the other, and we want to make sure it sticks around. Sometimes we have the concept of occupation rent, where one party takes over the home and basically perhaps excludes the other or something like that. But maybe the parties have to both continue paying the mortgage because they're on the hook, or maybe there are other reasons. So we have occupation rent, which is a discretionary remedy. The court won't always do it, but it won't always call for one party to pay the other. But it is a function of attempting to redress an inequity where one party is getting the use of the other party's equity by living in the house. Are they paying the expenses? Are they claiming for the expenses? Are there support considerations? The court may take that into account. Mary, I see you're there. Are you trying to tell me to stop talking, or you want me to answer some questions, or what should we do?
Sure, maybe let's see if there are any questions at this point.
Sure.
Okay, I'll give.
I don't have that ability to pull that up.
No, I've got them. There's no questions right now. If people have questions, perhaps.
I put them all to sleep.
No, you didn't. They're all still.
Let's hope.
Well, okay, maybe we'll let them formulate their questions, and you can go on with the Canada Pension Plan.
All right. The Canada Pension Plan is something that everybody contributes to if they're working and they're drawing a wage, or if they're drawing salaries and from a company, whatever. Everyone contributes to the Canada Pension Plan until they're, I guess, probably 65. It may even go longer. One of the features of the Canada Pension Plan is that the credits earned during the relationship, that's from the beginning of cohabitation until they separate, can be shared, and it's a simple application, and the forms get sent out to everybody when we file petitions and so on, so that they can just automatically apply and the government will do it. Manitoba is one of the provinces that doesn't allow you to waive that privilege. You can, and no one's going to force you to apply, but you can't stop someone from applying. So that's different than other provinces. One of the things that you care about if you're in a common law relationship is that you don't have to live together for the 3 years. If you've lived together for even a year in a common law relationship, you can get that equalization of credits. The downside, of course, is that if you separate, you have to make your application within 3 years of separation. So that may be a reason to pay attention and register under the Vital Statistics Act, and then to deregister, then it'll all be provable. Support gets enforced typically through the maintenance enforcement program. Most court orders where there's a monthly payment are registered with, well, I don't know if it's most or not, but certainly many are registered with the maintenance enforcement program, and they have a situation where the payor will usually pay by direct auto deposit, and the money gets into the hands of the recipient in the same way. And if there are late payments or arrears and so on, the maintenance enforcement program has great powers to go after people to force them to pay. They can charge penalties, they can charge interest, they'll garnish income tax refunds, they can apply to hold passports and driver's licenses, and ultimately even get people put in jail for not paying. The enforcement of support may be suspended on application if someone runs into a circumstance that they can show to the maintenance enforcement program that they ought to be cut some slack. They can get a suspension just by applying. There's some formality to it, but the forms are all out there. They can get a suspension, usually up to about 6 months on an administrative basis without having to go to court to get a variation. Other enforcement, I've got police contempt and penalties and so on. Those typically apply to abuse situations where we've got domestic violence, where we've got court orders, although sometimes the police will get involved in helping people on where there's custody abuses and abductions and that sort of thing. There aren't set rules about that, though, and you can't always count on the police to do what you think they should be doing, but sometimes they do things and you can't figure out why they're doing them. Contempt is a part of the litigation process. It's a difficult thing to prove. It becomes expensive to prove, and often it's not worth going down that road, although sometimes you have no choice to enforce a court order and get it. There's supposed to be penalties for the failure to give financial disclosure, and with every petition that's filed, we have to serve a demand for financial disclosure. And on those forms, it says a penalty of $5,000 can be charged. I've yet to see a case where that $5,000 penalty has been exacted against somebody. And I think some of the masters take the position, and they're the ones that we bring those motions in front of, that they don't have that jurisdiction. Now, moving on to this next slide, domestic violence is a big topic, of course, and the Divorce Act has now put a lot of stuff in its legislation about family violence in terms of custody and so on, and the responsibility of lawyers and so on to ensure that these kinds of things are looked at and considered, and that the parties are aware of them. In Manitoba, we have something called the Domestic Violence Act, which allows people to seek a without notice order of protection from a magistrate, and that is something that's fairly easy to do if you can put together the information that the magistrate needs to hear. People in family relationships, you don't necessarily have to be married, you don't necessarily have to be in a common law relationship. Could be a dating relationship even, could be a parent of a child who really has no relationship to the person against whom the order is made, can apply, and those orders are granted if you can prove that there's a legitimate basis for fear, that there's going to be some physical or mental assault. Any kind of physical touching that causes fear may qualify. Those orders are granted on a without notice basis, or an ex parte basis, as that's known. And once they're served, will be enforced by the police. And once they're served, people then have the right to go to court to try to have them set aside, and there are special dockets and processes to deal with that. The kinds of things that qualify are not just hitting, striking, beating, and those sorts of things, but psychological, emotional abuse, sexual abuse, stalking, following people around. Those may all be the kinds of things that will persuade a magistrate to grant that order. And the statute now provides, in recent amendments, that employees can get time off work as a result of domestic abuse, and they may get paid for some of that time, and that they shouldn't be subjected to any kind of job insecurity as a result of it. Now, I really don't know how that's worked out in terms of the stats, and if people actually do get those benefits. It's not the sort of thing that comes across our desk, because it just wouldn't be worth people's time or money to try to pursue that. But I'm guessing that it's got persuasive value and is a good thing socially overall. But I have to say, I don't really know a whole lot about it. The law has also changed recently to encourage mediation and arbitration in a way that it didn't do before. These things were out there, but the Arbitration Act has now been amended so that arbitrated decisions are capable and are available in family law, and an arbitrated decision becomes a judgment of the court enforceable as such. The Divorce Act now requires lawyers to keep their clients informed about mediation, alternate dispute resolution mechanisms, and arbitration, and that's becoming a much bigger field all the time. And there's lots of advantages to that, in the sense that arbitration can be private. Currently, files, well, at least until recently, files in the family division were open to the public. Any member of the public could go down and read a court file. Now the law has been changed so that those files are now not accessible except to the lawyers, the parties, or with a court order or the consent of the parties, which is a great step forward in some senses, and in other senses, I think, closes down the open nature of the judicial system. That's one of the hallmarks of it that we've had for centuries. In terms of process, things have now changed in terms of particularly the family division, how we go forward in litigation. We start with a petition for separation or a petition for divorce, and answers and replies and those sorts of opening pleadings. But after that, we move now to a dispute resolution system, the first step of which is triage. That word is used in the sense that it's used in the medical sense. It's supposed to be a way of determining where to send a case to get it resolved. Is this an emergency? Is this urgent? How many things are really at issue? What are the things that we can resolve? So triage is an opportunity for the parties and counsel to meet with a judge in what's called a without prejudice setting, meaning that what is said and done, unless there are agreements or orders that get made, is not to be used in later proceedings. So the theory is that people are going to let their hair down, as it were, and negotiate and do their best to settle their cases. But in order to get to triage, you have to certify that certain prerequisites have been completed, and those prerequisites are strict and demanding. If you haven't completed them and you can't certify, and the lawyers certify and the clients certify that they've been completed, you will not get to the step of having the matter set down for triage. So what are the prerequisites? In custody cases, the court wants to know, is there an assessment? Are you applying for an assessment? Has an assessment been undertaken? Has there been full and complete disclosure so that the court can deal with the issues of support for a partner or for children, so on and so forth? So what are the issues in the case? Has there been the completion of what's called a comparative family property accounting, which is an elaborate form that each of the parties fills out. One fills it out, then the other one responds to it on the same form, and then that form is then filed with the court. So all these things have to be put together, and the court has to be satisfied that they've been done properly before it will let you get to triage. So getting to triage is typically a 3 to 6 month event. And if you're paying a lawyer, ends up costing thousands of dollars often, or you're on legal aid, then it's not costing you, but it's costing the system. For you to get to that point where you're meeting with a judge, and the judge is going to then give you his or her view of the case. And typically, each party will file a triage brief, which in many cases runs to several inches of paper that the judges will read and digest, and will have in their brains, hopefully, when they walk in that courtroom to deal with things. Now that we've had COVID, the courtrooms are no longer quite as people friendly as they used to be. And we used to sit around big round tables and get friendly and sing Kumbaya. Now we're back sitting at desks with plastic stuff between us, and the judges back sitting on their dais with a plastic shield around them. So it's not quite as friendly as it used to be, but it still happens. And most cases, I would say, probably don't make it past triage. Most cases probably get settled either at triage or the next step along the line, which is case conferencing, which is, as far as I can tell, just triage number 2. It's really the same thing, but they've kept that name, which is the way it was called before we had triage. If you get past triage and you haven't settled your case, the judge will usually set the case conference date within about 30 days or so of that first triage meeting. And at the case conference, if the case isn't settled then, the court will set a trial date, typically 12 to 15 months down the road. We'll get the family property reference going, which is the separate process that we have to settle the family property issues. Something I guess I could talk about a little more if you want to hear about it. And if there's going to be an interim motion, which was something that was a major feature of the old system and is now almost non-existent, if there's going to be still an argument that the triage judge deems is sufficiently difficult and incapable of resolution and that warrants an interim motion, the triage judge will set an interim motion. And the thing about that, of course, that's important is that the triage judge will also be the case conference judge, will also be the interim motion judge. So typically what we hear at triage is, well, you can bring a motion if you want, but you've heard what I've had to say about it based on what you've represented to me. It's not sworn evidence, that sort of thing, at least some of it. But my thinking is along the following lines. Do you really want to go to a motion? Because if we end up hearing the motion and we end up with a result that's typical or similar to what I'm suggesting, what would be the right thing to do now, well, then there may be some costs payable. So think hard about that. Do you really want to go ahead with that interim motion? And so on. Now, some people, of course, do, and sometimes those motions get heard. And sometimes, though, the triage judge may say, no, this isn't urgent enough, this isn't important enough, or whatever. It's going to have to wait till you get to your trial 12 or 15 months down the road. So that may or may not be advantageous to one of the parties or not. But that's the way the system now goes. So a lot of cases do get settled at triage or at that first case conference, and sometimes there may be a second after triage. Sometimes if you have a very complex case, you can ask for, and the court will consider setting up something called JADR, which stands for Judicial, I thought I'd had it in this slide, I guess not, Judicial Assisted Dispute Resolution. And sometimes they'll give you a day or even 2 days to have this JADR, which you will file lots of material, and you'll be prepared to meet with the judge separately, together with the other parties. Sometimes the judge may do it on a shuttle diplomacy basis in order to attempt to resolve the matter. But unless the parties are really of a mind to settle and are willing to take the advice of the judge, who's going to have a whole bunch of material in his or her file, then that's something that is not likely to be undertaken. Do you have a question there, Mary?
No, there don't seem to be any questions. People, I guess
Just
maybe
boring them to death.
well, I think it's after the long weekend. They're all kind of, tuckered out from all the turkey on
Too much
Thanksgiving,
turkey.
I guess.
All right. Well, I'll try to wrap this up anyways.
Okay.
So as I say, this matter may end up going to a trial, and a trial is usually a difficult and expensive event. And you don't want to go to a trial unless you can afford it, unless you've got something really worth fighting about. Once a trial date is set, it will not be adjourned unless you can convince the Chief Justice of the court to adjourn it. And he's made it very clear that he's not going to be adjourning trials. Once in a while, someone, gets very sick or something like that, and that may sway the day. But unless this matter has been made ready for trial, the court doesn't care. It's going ahead and it's going to happen and it's going to get done. So I've got this other slide. Looks like it's a little out of order. Prerequisites to triage. I'm not going to go over that anymore. You'll see this when you get the PowerPoint, and you can follow up any of these things on my website. You know, the address that was given on the front cover. I talked about the triage conference already. So the judge is going to do their best to get the thing settled, or to set up the steps that they perceive are needed to get it done. The disclosure, they'll set timelines, the family property reference, about which I have not spent any time talking about so far. They'll get that going. It's a parallel proceeding in front of a master of the court as opposed to a judge, and it will be geared to settling again in a series of meetings with the master, meetings for directions. They will try in a similar way that a triage judge will be, to narrow the issues, to determine what the evidence is going to be. And if necessary, there may be a 2 or 3 day reference trial, at the end of which the master will make a report. That report will be submitted to the trial judge. So it has to all be done before the trial. And the trial judge will then confirm or not confirm that, depending on how the parties may ask for it to be done. Here's the thing about case conferences and JADRs. I've done that. Parties have to certify 45 days before the trial that they're ready. And if they're not ready, then they have to meet with the Chief Justice, not for the purposes of canceling the trial, but for the purposes of discussing what costs will be assessed for not being ready for trial. Only the Chief Justice or the Chief Justice's designate, typically in the family division, the Associate Chief Justice for the family division, can cancel the trial. And as I've said before, they do not want to cancel trials. I talked about the Arbitration Act and how useful that is. And this last page is a series of links that will get you to some of the places you want to go to do research, find out things, and that sort of thing. And again, I'm going to promote my own website, which is the first thing on the list. There's lots of information in there, lots of links, some of which are duplicated here, but to various things.